Thank you all for joining us this afternoon after the really extraordinary keynote talk you just heard. This really set up neatly by that talk is a discussion of the Endangered Species Act and water compact issues. We are fortunate to have two excellent speakers, and having only two speakers will also leave us time for discussion, never a bad thing in itself. Our first speaker will be Karen M. Kwon, the Office of the Colorado Attorney General. Karen is a fourth-generation Denverite, was appointed first Attorney General to the Federal and Interstate Water Unit in 2012. Her work includes compact litigation and negotiations in the Rio Grande and Republican River basins. She's also familiar with the Arkansas and South Platte basins. Regarding general compact matters, she coordinated the amicus briefing before the United States Supreme Court for the AG's office in the Tarrant Regional Water District versus Oklahoma case, as well as the Western States amicus brief in support of Alaska's petition for cert in Alaska versus Salazar litigation. Her experience also includes serving as an upper basin representative in negotiations with the Department of Interior and Mexico on minutes 317, 318, and 319 to the 1944 Water Treaty, testifying on behalf of the Upper Division states at congressional hearings regarding the Grand Canyon, serving as coordinating counsel for the 7 basin states in the Grand Canyon Trust versus Department of Interior litigation concerning operations of the Glen Canyon Dam, and negotiating and drafting language, my goodness, to address compact concerns in authorizing the Navajo-Gallup pipeline legislation. After Karen, we will hear from James J. Tutchton. Jay has been a public interest environmental attorney for over 20 years. Prior to coming to Defenders of Wildlife, he was general counsel for Wild Earth Guardians. And before that, he was an attorney with the law clinic at the University of Denver College of Law right here. As a staff attorney for the Center for Biological Diversity, Earth Justice, and the National Wildlife Federation. Over his career, he served as director of the Environmental Law Clinics, already said that. Jay earned his BA from the University of Notre Dame, JD from UCLA, graduated Order of the Coif, did very well, worked on lots of things, and clerked for Judge Keller in the same courthouse where I clerked. And I neglected to mention that Karen also was a DU undergrad, though she did stray slightly and go to CU for law school. Karen.
Good afternoon. I find it a little bit daunting I looked at Pat and I said, I'm not that excited to have to follow up at lunch after your talk, but we'll go from there, and she did tee up the Endangered Species Act for us. So I do have to do the little disclaimer, the lawyer in me, that the views that I'm expressing today are my opinion as Karen Kwon and not representing the opinions of the state of Colorado or any of my clients. So today we're talking about the Endangered Species Act and interstate compacts. And as the first Assistant Attorney General for the Federal and Interstate Water Unit, what we end up doing is trying to, as I think has been alluded to, is trying to find ways to address federal regulation and environmental regulations regarding water in a way that can fit within the state water law framework. Endangered Species Act matters have the potential to implicate all aspects of federal and interstate water implications in Colorado. They obviously affect allocation and use of compact water. They also affect the interplay between federal and state roles to manage wildlife as well as water and use and administering water. And they also have the ability to, the Endangered Species Act can influence or impact how water users within our state can realize the full potential of their water rights. So there's big stakes at it from our perspective of how to mesh the Endangered Species Act with water rights administration and compact administration. From a state perspective like Colorado, there's specific considerations we should keep in mind. the goal of conserving species and preserving species is it helps Colorado promote a quality of life. We in Colorado, as a fourth generation Denverite, but as well as a lot of people who've moved here, live here for a specific, very good reason. We like it here. We like the quality of life here, and I don't think we all like it here because of the added traffic and the added exhaust. We like it for the wildlife and the nature and the skiing and the recreation, and with that goes preserving and conserving our environment, including wildlife. We also, that quality of life requires us to try to work towards and preserve a certainty in the availability of water supply. We just heard about climate change and the demands and increases in population and the demands for increases in uses of water. All we are trying to do is maintain that we have a certain water supply moving forward into the years so we can avoid a crash or avoid a conflict. And finally, the state perspective is to maintain our own ability to manage and control our own destiny. As a state attorney, I think it's obvious and not a surprise to represent that we like to maintain our own ability to manage the resources within our state. We don't like the federal government coming in and telling us what we can do with our resources, and we don't like other countries coming in and telling us what we should or should not do with our resources. So to the extent that we can try to fashion a framework for managing resources that allows us to maintain and control our own destiny so that we can attain a reliable water supply and preserve our quality of life, that's ultimately what we're trying to work for. Now, there's two sides of the Endangered Species Act coin, and I don't know, I think I'm right smack dab in the middle. I'm not a pro-Endangered Species Act nor a detractor of it. I think is it working? In some ways, yes. Is it working enough? I don't know. I don't think it necessarily is. The yes is that, I mean, it is obviously, and my undergrad here at DU, my environmental professors would be remiss if I didn't acknowledge that it is the Endangered Species Act is the law that has teeth for lawyers and interested parties to effectuate a change. And that's not always the case with environmental laws. So it does have significant power to stop things or to effectuate a change. It provides mechanisms for enforcing values, and it has a way of protecting and recovering species. And at base, it has prevented the extinction of a number of species. But on the other hand, how successful is it? I mean, if we're just trying to stop extinction, that's one thing. But are we actually trying to improve and recover species and have it in a way that's working symbiotically with our ability to live in the same area? I'm not sure the Endangered Species Act is working very well. It's arguably, I'm not going to quibble over the actual percentage of how many species have been delisted through the operation of the Endangered Species Act, but it's arguably around 2%. It is also viewed as to many, as a threat as opposed to a tool for attaining species conservation. It is more of a, well, if you don't do what we want, then we're going to threaten you with a lawsuit. It's a threat to go to court. It doesn't necessarily, as I think we've been alluding to throughout the day, serve as a tool for resolution and solution. And by that, I mean, if we're actually going to work towards achieving long-term sustainability and recovery and flourishing and making species common, the Endangered Species Act is not an incentive for that. It doesn't incentivize people working together to try to find solutions because there's no certainty that that solution will be upheld and maintained throughout the future. So I was going to bring these things up thinking they had not been brought up today, but the Bay Delta has been discussed a little bit today. There are two main, in my experience, on the Colorado River and on the Rio Grande, there are two main Endangered Species Act issues that are rising to the level of concern regarding interstate compacts. The Bay Delta, as Bill Hazenkamp and Pat Mulroy have both referred to, it isn't in the Colorado River, but the fact that it can cut the water supply that's going to Southern California so dramatically directly affects the Colorado River. And basically, it has stopped or significantly reduced the ability to get water from Northern California to Southern California. Just as significant and just as contentious is the silvery minnow in the Rio Grande. Over through the 90s and into this century, the silvery minnow has had a hard life in the middle Rio Grande in New Mexico. And it is because we have a compact from Colorado, New Mexico, and Texas regarding the Rio Grande, and we have our allocations for how where the water should go to from Colorado to the Elephant Butte and to project area below there. There's this minnow in between Colorado, it's in New Mexico above Elephant Butte, and development within New Mexico is drying up the stream, and it's affecting this endangered species. So much so that this is where I think if we were going to have an Endangered Species Act versus compact fight in the near future, this is where it would come from. Now, the question will be, is will litigation actually, will we go to litigation on something this significant where it won't just be the parties to a compact, that compact, and the environmental interests in litigation. If it's going to be an Endangered Species Act versus compact fight, I bet anybody who's entered into a compact and anybody who has an interest in the Endangered Species Act are going to want to intervene in the case. It will be earth-shaking if that is going to be the type of case we're going to have. The question is, nobody knows what the results will be. So going in not knowing and it having such big stakes at hand, that's why we haven't had a lawsuit like that up till now. There's more interest and more political will to sit down and try to figure it out. And I've cut my teeth on working on the Colorado River and developing partnerships, so I'm very hopeful that the same could happen with the silvery minnow and the Rio Grande. From my perspective of representing states on these matters, I think Pat brought it out very well, is that if we are going to get to long-term solutions, then the primary question needs to be, how do we, regarding the Endangered Species Act at least, is how do we effectively accomplish species preservation and conservation within the existing framework for allocating and administering water in between states. If you're throwing the framework that we have into the air and starting all over, you're going to have a much bigger fight. What we need to have is recognize what we have to work within, find the flexibilities, bend it without breaking it. If we break it, then there's more losers and other winners, and we'll be willing to go to a lawsuit. And as a lawyer, I'm not advocating that we should be in litigation on this. The only winners are the lawyers who make a lot of money on it, not attorney generals, assistant attorney generals, by the way, but the private law firms. But if we actually want to have long-term results, then we need to figure out ways to bend the framework without breaking it. In Colorado, we have done that in a number of ways, or we're trying to do that in a number of ways, and it's not just because we're scared of a lawsuit. We actually are concerned with and value the wildlife. As I mentioned, it's key to Colorado's way of life. Our quality of life would be diminished when we can't see wildlife outside our front door or know that there are landscapes where wildlife can flourish. Our quality of life is diminished when businesses are forced to board up because they can't figure out how to help a species within the Endangered Species Act limitations. And our quality of life is diminished when decision-making over resource management is taken from people familiar with the landscapes and species and businesses throughout our state. So because we want to try to maintain our quality of life and avoid these situations, we haven't just paid lip service to this. We have a Colorado policy, we have a strategic plan within the Colorado Parks and Wildlife, and we have the Colorado Water Conservation Board has a specific role in trying to avoid listing of endangered species, and I think as the director of CPW has mentioned, is to keep species common in Colorado. That's their goal, is to try to keep species common. And it is an all-out effort in these aspects. Their goal, as I say, is to keep species common and help recover species and get them delisted from threatened or endangered status. And to do this, Colorado Parks and Wildlife, under the Department of Natural Resources, in conjunction with the Division of Water Resources in many cases, and the Colorado Water Conservation Board in other cases, spends a lot of time and money and resources collecting and analyzing data on all Colorado wildlife, not just the threatened endangered ones or candidate species, but all Colorado wildlife. And they try to develop partnerships and collaborate with local citizens, industry, and lots of different areas to collaborate and conserve species and balance the economies. And in doing so, the state is we're not trying to hammer that it is our authority and our rights and our capacity as a sovereign to be able to do whatever we want, but we want to be able to preserve our ability to manage for the benefit of the citizens of our state. Examples of this have been to develop partnerships in conservation, share data and information, and pool funding to avoid listing. CPW has been very active in this in the past couple of years. And even in the event of promoting, if we have a listed species, then the efforts are focused on providing resources to help identify the status, update the science, identify ways to recover and facilitate collaboration, and develop legal mechanisms to promote recovery. An example we have we have one of many examples, but the Upper Colorado River Recovery Program is a perfect example. That program was developed in a way, I'm going to summarize it very quickly, but the Upper Colorado River Basin has an allocation of water from the Colorado River Compact and the Upper Basin Compact. But for us to be able to actually utilize that water, we have federal facilities, the Aspinall, Flaming Gorge, Navajo reservoirs, among many others, and our development projects. Well, if we're going to develop water, we're going to, without considering the endangered species that are in our basins, then we're going to run right in front and head on to the Endangered Species Act, and we'll be accused of having a take, or the federal facilities won't be able to be operated because they aren't considering whether the species are being jeopardized or not, and all of those kind of things. So to avoid that, or to help facilitate around that, there's been a collaboration and a partnership developed where they've developed the Upper Colorado River Fish Recovery Implementation Program, and in that it's designed to recover the four endangered fish species that have been identified in the Upper Basin, while allowing the water users to continue to develop and utilize the compact apportionment that they are entitled to under the compacts. The partners include Fish and Wildlife Service, the Bureau of Reclamation, Western Area Power Authority, Colorado, Wyoming, Utah, water users, and environmental groups throughout. It allows for Endangered Species Act compliance, where there would be either a no jeopardy finding or an incidental take statement, which would allow us to be able to incidentally take a species without being accused or charged with violating the Endangered Species Act. To do this, the program involves flow augmentation in certain areas, like the 15-mile reach close to Grand Junction. It allows for spring peak flows and late summer fall flows to maintain fish habitat. It's non-native fish control, especially in the Upper Basin on the Yampa, to the non-native fish that are predating on the endangered fish are being controlled. Screening of large diversions and construction of fish ladders to increase habitat accessibility. These are examples of the types of programs that are going on that are expressly funded by the partners to maintain compliance with the Endangered Species Act and allow us to realize our rights and benefits of our compact. Another one, as I just flipped through really quickly, is the 15-mile reach. Let me see how to, I know how to go backwards. There we go. The 15-mile reach, as I say, is close to Grand Junction. It's in the Colorado River. And what's interesting here is an example of how our state is trying to maintain or avoid conflicts with the Endangered Species Act and compacts, because the Colorado Water Conservation Board in this situation was acquiring in-stream flows to maintain flows in the 15-mile reach so that the fish species in the area can be preserved and development elsewhere can continue. For the CWCB to do this, it's not, if they went and got a water right now for the in-stream flow, it wouldn't necessarily accomplish very much, but they were able to get an acquisition proposal of a short-term lease from the Ute Water Conservancy District for up to 12,000 acre-feet of water from Rudai Reservoir. And they use this in the 15-mile reach of the Colorado River to preserve and improve the natural environment to a reasonable degree. That's the requirement under the in-stream flow statutes for CWCB. In Colorado, the only entity that can maintain an in-stream flow right is the Colorado Water Conservation Board. And so to have in-stream flow opportunities, the CWCB is the entity that needs to be involved. And they are active. There's a very large, I would say, a very large group of within the CWCB who is dedicated, and our office is dedicated to identifying these types of flows to help facilitate the quality of life within our state, as well as help accomplish compact and ESA working together. The benefits of the leased water will help bring flow rates to the decreed in-stream flow rates at 15-mile reach. It'll help meet the Fish and Wildlife Service's flow recommendations to avoid a jeopardy finding, and it furthers the goals of the Upper Colorado River Recovery Program. In 2015, the CWCB leased 9,000 acre-feet of water that was released from Udai in September and October, and they're looking at what they can do this year as well. We have other examples. We have the San Miguel in-stream flow and the Dolores in-stream flow that are in similar situations, as well as the San Juan River Recovery Implementation Program, the Platte Recovery Implementation Program, the Grand Canyon Adaptive Management Program, and we can't take credit for this in Colorado or the Upper Basin, but I think a good example of trying to find ways for the Endangered Species Act to work within the existing framework is the Multi-Species Conservation Program in the Lower Basin. In that instance, a number of entities, industry, water users, states, governments, have all pooled together a considerable amount of money to help create and preserve habitat in endangered species and species throughout to avoid listing or recover species that are listed. Let's see. Challenges, though, of the Endangered Species Act. Again, as I say, the way it's used right now is it's used as a tool. It's a legal threat. I mean, the challenge is to how we can use it as a tool and not a legal threat. We are in our state, for example, have been working very hard to try. I'll take the sage grouse as an example. The sage grouse is something that Colorado Parks and Wildlife has worked very hard to find ways to conserve the species and avoid a listing of endangered, threatened or endangered. And they've dedicated a lot of time and a lot of money and a lot of resources, along with the landowners and water users within the area, to collaborate and to maximize the expertise and resources and to identify a solution to conserving the species without there needing to be federal regulation. The same has happened, I think, in the Rio Grande with the southwestern willow flycatcher and a number of fish species. They've developed a habitat conservation plan among a number of water users in the area, dedicating a lot of time, water, resources, money to ensure that they would not be subject to a take finding in using their water supplies. The problem with that, though, is that they've developed the habitat conservation plan for the species that have been identified. Well, then the next day another species is identified and it doesn't apply to that habitat conservation plan. There's no certainty in whatever efforts that we're using will extend into the future. And if they don't have any certainty, there's no incentive to spend all that time and money and energy to find the solutions. And that's where I think there's a huge miscoming or a huge gap in the effectiveness of the Endangered Species Act, because it doesn't encourage and allow people to really work together to find long-term solutions, because they can still be slapped with a lawsuit with the next species that comes down the line. Another question is it's all based on, and it highly encourages that it's all based on listings and recovery are based on best available science and resources. The problem is what science is available, how is it best, what does it mean, who gets to interpret it, and all of those kind of questions. And I think an example in the Grand Canyon is very indicative of the situation. Is we've been studying the environment and the species in the Grand Canyon for decades and for millions of dollars. And I will say that the species that is listed, the humpback chub, at least one of them is not extinct, and it is recovering, and that is great in a lot of ways. But we cannot agree as to whether we need warm water. Well, that would encourage non-native warm water fish species to come and predate on the species. No, do we need less fluctuation, more fluctuation? I mean, we can't agree on these things, and it's just because there's competing science. And so we continually need to upgrade the science. And then I think, as Pat pointed out best in her speech, is that we need to recognize the complexities and work to address all of them. Just saying no and it has to happen regardless is where you're going to get doors shut and people in court. If you actually want to have solutions where we can have long-term progress, then we all need to recognize the interests of the players at the table and invite all of the players that need to be at the table to begin with, so it can be set at the same time. And I think all of these are necessary to avoid the ESA and the federal and interstate water conflicts. So my takeaways are, the challenges to address are growing. We're learning that achieving goals and realizing the benefits of the Endangered Species Act and interstate water allocation requires a commitment to utilize the knowledge and expertise we have, consider all the interests that are at stake, collaborate, and adapt. Otherwise, lawyers, as I say, will be the primary benefactors of the Endangered Species Act, not the water users and not the species. Thank you.
Okay, well, so I'm Jay Tutchton with Defenders of Wildlife again. I guess I should disclose I'm probably one of those lawyers who's benefited substantially from the endangered species. Not in a monetary sense, but I've probably filed 150 lawsuits using it as a jurisdictional prison. But so I'm that guy. And I thought I should start with just a little bit of what it's about. I'm an Endangered Species Act lawyer, not a water lawyer. The Act is really a three-part play with three key sections, which go by their bill numbers, 4, 7, and 9. It works on the basis of a magic list. So people on my side of the fence are all about putting things on the magic list of threatened and endangered species, which we view a lot like Schindler's List. If you're on it, you've got a decent chance of survival. If you're not on it, your future looks very bleak. So we look at it as this magic list. Species is a bit of a misnomer. It's species, subspecies, or distinct population segment of vertebrate species or subspecies. That's where a lot of your fish come in. So all your winter run Chinook, coho here, in this stream, those are actually DPSs. They're not individual species, but the Act protects these distinct population segment of vertebrate species as though they were full species. Section 4 process, as Karen said, is based on the best available science. It can be started by a citizen petition to convey Endangered Species Act protection to a particular species. If a citizen files a petition, it triggers obligations on behalf of the government to respond to that petition by certain deadlines, using this best available science standard to evaluate the petition. And both sides of the community have spent a lot of time arguing about listings, and as Karen mentioned, sage grouse was last year's big to list or not to list dispute. And I often think that is a misplaced argument. And misplaced in a couple ways. First off, listing should be diagnosis. And the analogy I always use is cancer. If you want to know if you're going extinct or if you have cancer, that should be a simple yes or no question you just want your doctor or your best available science to answer. But people front load the debate about the course of treatment. Those are the later sections of the Endangered Species Act. I think that's a totally legitimate debate. What are you going to do, or what are you willing to do to solve this problem? But by trying to deny the problem exists, I think we end up arguing about the wrong thing. We argue about whether or not sage grouse has declined when, it's abundantly clear they have declined. The question is, how much versus what are you going to do about it? The other thing is the states engage in this significant effort to avoid listing, to avoid federal regulation through the Endangered Species Act. But the way they get there is to either regulate themselves or use an alternative regulatory process. In the case of sage grouse, all your land management plans for the Forest Service and the BLM. So they get regulated one way or the other. They are just in this mental state where they would prefer to be regulated by the BLM or the Forest Service through a land management plan than by the Fish and Wildlife Service through the Endangered Species Act. But the regulation is coming because it's necessary to resolve the problem. So anyway, the disputes over listing, I view as not that productive for anyone. I think you should recognize the problem based on the science you have and move on to fight about what you're going to do about it or not do about it. Those are the other two sections of the Endangered Species Act. Section 7 is what's known as the consultation process. In the vernacular, that's the federal government stop shooting yourself in the foot sort of process. So it requires the federal government to stop doing things that make the situation for endangered species worse through what they call interagency consultation. And in the water world, this normally involves the Army Corps, or the Bureau of Reclamation, having to ask the Fish and Wildlife Service, if we do X, will we jeopardize the continued existence of a species or adversely modify its critical habitat? And the Fish and Wildlife Service or the National Marine Fisheries Service has to answer that question for them, basically to get the other federal agencies to stop digging the hole. It's like, okay, we've got a problem, quit making it worse, we need to change our operations to get the species or the ecosystem on a recovery trajectory. The last big, that Section 7 only applies to the federal government, and I'll come back to that. But in the water world, that basically means everything, because there's very few things that relate to water that don't at some point involve the Corps or the Bureau, especially out in the West. The last major section is Section 9, which prohibits any person from taking an endangered species. And the key component of that definition is you can take something by destroying its habitat. So it includes more than just your traditional shot it, trapped it, otherwise killed it, but destroyed its habitat and caused it to die. And that would be a take. And again, that's frequently what dams do. They destroyed habitat, they take the species, and so they're potentially liable for take of endangered species. That's how the Act works. All that said, and for all the rhetoric about the Endangered Species Act, every analysis I've ever seen says this is a paper tiger. You know, people will call it the pit bull of environmental law. 99% of the projects are approved. So it's taking a very, very thin slice off the top, the very worst of the worst projects. But, you know, Defenders of Wildlife recently published an analysis of all the Section 7 consultations. There are under 20 where the agency ever said jeopardy in the last few years. You know, you're talking about a handful of things where the Endangered Species Act actually stops a project or modifies it significantly. That said, about its paper tiger nature, the water world is one place where the Endangered Species Act does seem to have greater impact and more draconian results because of the factual context that's presented. Most famous Endangered Species Act case involves TVA versus Hill, the snail darter situation, 3-inch fish that Justice Powell said was not even useful as bait versus a $100 million federal dam, 3-inch fish wins. Because of the factual situation that the court was presented with, which is if you shut the door of this dam, the fish goes extinct. It was a bright line situation, and you have that with water all the time. If the water reaches a certain temperature, all the silvery minnows die. So there's this real hardcore point. If you destroy this tributary, the fish die. If the water quality hits this level, all the fish die. And there's, you know, an objective data point. For most species, you don't have that. Which timber sale will wipe out the lynx? No one knows. Which ski area expansion will wipe out the lynx? You don't have these yes or no decision points like you do in water. And that's why I think the Endangered Species Act has kicked in the water environment in a more draconian or absolute way because of the fact patterns. You actually are able to point to a single decision that means extinction or not extinction. And just to give you an example of the wiggle room that exists for terrestrial species, unlike aquatic species, from last week, the decision to not protect the wolverine under the Endangered Species Act was overturned by a district court in Montana. The admitted facts are there's about 300 wolverines. Any of you walk over to the biology department and ask a student, there's 300 members of this species, is it endangered or not? Is it likely to go extinct in the foreseeable future? That's a dumb question. Of course it is. When you tell them further on, only 30 of them are functionally breeding because they're in proximity to each other. And you say, is that a tough question? You know, they're going to laugh in your face. And you throw on top of it, the species needs deep, persistent snowpack for breeding. One thing that climate change will most likely not allow to continue is deep, persistent snowpack. But Fish and Wildlife Service declined to list the wolverine. Because they're able to say sort of silly things in my mind, like, well, you've proven that the the wolverine dens in deep, persistent snowpack now, but you haven't been able to establish that it won't den in something else once the deep, persistent snowpack is gone. Now, never mind the 300 or the 30 functionally breeding ones, but they raise these issues that I view as just deliberate stupidity, because the act allows that, but or the facts allow that. There's no certain scientific answer. Yes, it dens in deep, persistent snowpack, but maybe it'll den in mud banks in a climate change world. We don't know. But with fish, it is a yes or no situation. TVA versus Hill, you close the dam gates, the fish dies. Silvery minnow, the river hits this temperature, the fish dies. So back to our issue of compacts and conflicts with the Endangered Species Act. The cases are pretty clear that the Endangered Species Act can force modification of water delivery contracts by the federal agencies, Bureau of Reclamation, Army Corps. The cases are also clear that the Endangered Species Act would force modification or curtailment of state-based water rights. I don't see a logical reason that or legal reason that in a conflict with a compact that the Endangered Species Act would have to give way. I think water lawyers view compacts, law of the river, as sort of talismanic laws that are more important than other laws. But they're just not. They're equivalent of other statutes, and all of these things are going to have to be reconciled. And there's rules of statutory construction that cut any way you want. Which one came later? The Endangered Species Act is 1973, 1922 compact. I don't know. I mean, you could say you've got to accommodate this Endangered Species Act, or the Clean Water Act, or the Safe Water Drinking Act, as we heard. But I think at the end of the day, all of that stuff is the law of the river. It's not just the things that water lawyers pay attention to, but it's the background suite of federal statutes, particularly when you have federal agencies running these rivers who are directly impacted by the Endangered Species Act and the Clean Water Act. That said, I think, as Karen said, that's not necessarily a battle that anyone wants to have, but I don't think that there's some asterisk behind the Endangered Species Act in conflict with a compact or a state-based water. But back to the more interesting discussion for me is its success. Parent statistics are right. If you look at it in a have we recovered species, the answer is about 2%. About 2% of the things that have been added to the endangered species list have officially been recovered. You can look at it another way and say 99% of them haven't gone extinct. It's sort of looking at the same data set from two different perspectives. There's a scientific article that says at least 400 things would have gone extinct in America but for the Endangered Species Act. So you could say it's a profound success and that it kept things from going extinct. You could say it's a failure and that it's got only 2% of them recovered. The point I think is more important is the ability of species to recover normally depends on what you're willing to do. And that's the debate I think that we should be having instead of this debate over are they or are they not endangered. If we tore the dams out of the Colorado River, we'd recover all 4 of those fish in about 5 years. You know, we might have to poison a few exotic fish to get them out of the way. But if you're willing to take certain actions, you can recover a species. No one's saying that that's going to happen. So yeah, those species probably won't recover for 100 years, if they ever do. They're on perpetual life support because of what we're willing to do. So the criticism of the act is a failure because it's not recovering species. I view it as just, well, what are you willing to give up? If you only want to very tinker with the margins of human behavior, human use of water resources, it's going to be hard to recover species. If you want to really turn that dial, you could actually do it very easily. It just means like getting rid of Glen Canyon Dam and the humpback chub in the Grand Canyon would be fine. But you can't do that, so you're not going to recover the species. A couple other points I wanted to touch on is the issue of local control, or the local people. I understand the desire to keep local decisions in local hands, but two sort of counterpoints. One is endangered species are of national interest. The membership of Defenders of Wildlife is all across the country. And I always say, you know, some little old lady in New York City has as much right to the Grand Canyon as the guy who lives on the edge. You know, these are national resources. We're one country. There's no asterisk because you're not local. The other point is, at least when you're talking endangered species, the need to list a species represents local failure. The federal government does not manage wildlife, fish or terrestrial wildlife, until it hits the Endangered Species Act. So the fact of listing indicates the state or the local entity screwed up. So for something like the sage grouse, Wyoming listed that as a species declining in 1954, and for 70 years managed it right into the ground. So when Wyoming says we need local control, I'm very unsympathetic because I say, we let you do that for 70 years and you stunk at it. You did a really bad job. Not to pick on Wyoming, I could pick on a dozen states and a dozen species, but the reason the Endangered Species Act is there is to address local failure or state level failure. And so the idea of turning it back over to the people who got us in that situation is a little upsetting to people on my side of the aisle because they're the ones who got us in that pickle in the first place. And then I guess a couple other points that I just wanted to make is, because they've come up a bit, is, and I hear them all the time, is drought is an interesting one. You know, the Republican River, the Arkansas River Basin, are the area that is also called the Dust Bowl. The idea that there's drought there should not be surprising to anyone. And drought, you know, I wish we could get rid of the word drought and just replace it with normal. Like, we live in drought. This is an arid West. And so the surprise or the hand-wringing that occurs from historic droughts should just be normal. What's actually abnormal is when it rains or snows significantly, particularly in some place that's known as the Dust Bowl or the Imperial Valley of California, which is like 2 inches of rain a year. The last point I want to make is with what's the future look like. Whatever you think about the Endangered Species List or the Endangered Species Act, it's currently underrepresented. There are about 1,500 domestic species on the Endangered Species Act. Most scientists would tell you that number should be between 6,000 and 8,000. So the problems are not going away. It's something we'll have to come to terms with. And there are some fundamental conflicts. We run our rivers really, and you can find maps that will depict it exactly like this, is bathtubs and faucets. Species need rivers that were rivers, that fluctuated seasonally, that flooded, that overran their banks, that do all sorts of things that people don't like. And so, again, I think water management in the Endangered Species Act is a particular flashpoint of conflict because there's less ability to have shared inputs. Like people on my side of the fence would look at the Colorado River and say it's a disaster. It's not a river anymore. It doesn't normally make it to the ocean. It's just a series of dams lapped up against other dams. You could say the same thing about the Missouri River. These things aren't rivers in an natural environment situation anymore. And so the workarounds are very, very difficult to get to because the species evolved when they were rivers, not when they were conveyance systems, or basically as we treat them as pipes. One last quick point, because I got a minute. And this I feel I have to do because I assume there's some law students here. I speak on supportive litigation. Right? That's what I do. It's a valid dispute resolution methodology. There's nothing illegitimate about going to court or wrong about it. It may or may not be the most efficient way, but I can tell you from the folks I represent what it is it's the one place where we do have a voice. We are not the folks who are invited to the table, normally speaking, in any of these collaborative processes. When I was a very young lawyer and working for a corporate law firm, one of the pieces of advice I was given was, keep our clients out of the courtroom. Our clients will never get hurt in Congress, they'll never get hurt in the legislature. The one place they could get hurt is if you let them get in courtroom. And now representing public interest groups, that's why we want to be there. In other words, we're never going to lay a glove on a major water district or water project in Congress or in the executive branch. But the one place we can get someone to pay some level of attention to us is in the courtroom. So it may be a perceived threat, but I think it's a necessary threat to give unpopular or politically marginalized interests at least a seat at the table. Thanks. I think we'll have some time for questions.
No, I appreciate Jay's comments. I do want to make sure that a couple points that I would like to make are, I do think that litigation is a necessary tool to be heard in critical points, and if there's local failure on something, I think that the Endangered Species Act appropriately exists to allow a citizen suit to rectify the situation. However, I think if it's used as a tool to continue to be in court continuously without a willingness to sit down and problem solve, there's a couple of things. You're never going to be invited to the table to problem solve if you're dragging us into court all of the time. A perfect example of how that has worked is that when we were negotiating with Mexico, the most recent Minute 319, there is a huge environmental component to that minute, including environmental restoration of habitat and a pulse flow that allowed the water to reach the delta for the first time in decades. I'm not trying to hold it up as so it's all solved. I understand that. But there were two key people who had built relationships and who had gained the trust of the states and the countries to be able to be at the table to help negotiate from the United States side the success of that minute, and it was primarily because we knew they were not going to be taking us to court. Another issue is, and I agree that the Endangered Species Act has a strong argument as to why it could trump a compact, but I think what we have learned from, I don't think it's 100% slam dunk, and I think what we've learned from today's conversations is that you can win the litigation and still lose the war, because while it might trump a compact, if you're going to stop a water supply for 40 million people and irrigated acreage of 4,000 people, I'm pretty sure Congress is going to step in at some point in time. So if we want, I guess my guidance is that if the Endangered Species Act is going to be used as an effective litigation tool, it needs to be used with that in mind. You don't want to use it so much that it forces the public will to want to break it. It's the same framework that we want to find flexibility in without breaking. So those are the two things I wanted to comment on.
There's a question?
Well, it's not a question, it's a comment. Is that okay? I need your permission.
I guess, yes.
Conditionally, is it okay?
It is certainly all right.
You can withdraw the permission after I speak.
I doubt that.
Microphone?
Use the microphone.
Yeah, there's actually a mic right there. That is the condition I will impose.
Ooh, is it working?
No, that's, that was also part of the condition, no. We'll see if we can fix
Supposed
that.
to bend it, not break it.
Oh, yeah.
That's very good.
No, I'll hold it. I think I'll hold it. So I was going to make a suggestion, and the suggestion is if you step back from the Endangered Species Act and you take the perspective that I think Colorado is brilliantly taking, it would be advantageous, I think, politically and otherwise, perhaps normatively, to give it a different name. So you can't protect the environment. You can't sustain an environment through the Endangered Species Act. You can find canaries in the coal mine, right? You can pointillistically help a species in the hope that it will help other species and things like that, although that's not really the basis of the conversation. But I think when you spoke, Karen, about protecting the environment, about making sure that species remain common, really you've exposed the fact that the carapace of the Endangered Species Act is being extended beyond its breaking point, really, by a new kind of policy. And the policy really is environmental sustainability. And that's not what the Endangered Species Act can accomplish. I think paying attention to that could lead to some really wonderful developments. And I'm not here to say you're not paying attention to that, but I want to make specific recommendations of two very modest sorts. One is to understand the environment, to understand things like when might you have an extinction cascade, when have you really protected an entire environment's worth of species. You've got to have fundamental discovery science, not just applied science, going at these questions. And the state has to decide it's going to support that through whatever set of means. And I want to suggest that fundamental discovery science is at the root of doing the work that the state wants to get done. The other thing I was going to suggest is that from a different field entirely, and they study this stuff in business schools more than in law schools, studying risk management under conditions of uncertainty would be a very useful undertaking, because that's essentially what we're doing or trying to do. Thanks.
Thank you.
Now.
Well, since all of you are cogitating on your questions, I will take moderator's privilege and actually turn your question into, your comment into something of a question, which is right. So 35 or 40 years ago, Pat Parento, in a moment of bad judgment, called the Endangered Species Act the pit bull of environmental laws. He's been trying to walk that back for about 3 decades, but the metaphor will not go away, right? It's always got fangs or teeth or occasionally claws. No one ever talks about the Migratory Bird Treaty Act having teeth or even a particularly sharp beak. Right? It's the way we think about the Endangered Species Act. In fact, the Endangered Species Act is just a law. It endeavors to resolve disputes between human economic activities and the very existence of other species on the planet. But it's a law that expresses, particularly in the water context, a fundamental reality, which is that the water you allocate, or that we allocate through law, is also a place that other creatures live, and in the arid West, particularly, on which other creatures depend for their life. So, how should we deal with that reality in our system?
Well, if I understand your question correctly, we're trying to figure out how to allocate the water to meet the economic and life needs that we need of the people while accommodating the same needs for the species.
Correct.
I think that is the ultimate question that's the balance we're going to have to try to strike. And I mean, I don't think it's at the to the extent of saying, oh, some species can go extinct, but to the extent they can be recovered, it's kind of going to what are we willing to do? And I don't think we are willing to take Glen Canyon Dam out of operation, but I do think that there are ways. I'm not trying to be naive. I've seen it happen where we have been able to sit down and with people who were diametrically opposed in their views and their positions, and sit at a table, and it takes time and it takes relationship building, but there are ways to identify how we can get enough supply of water in the stream to preserve the habitat while maintaining the ability to realize the rights and benefits of compact allocation at the same time. I don't have a specific answer because I think it's going to be on a case-by-case analysis. I think what happens on the Colorado River is completely different than what happens on the Rio Grande or the Arkansas or Republican, for examples. But I think that the risk management weighing and cost and benefits, it behooves us all to sit down and be at the table to try to figure out the solution.
Well, I'll just quickly, I think there's still room for compromise. We're not at we want the species around, or are we willing to throw it under the bus to grow alfalfa But what I see often is there's brilliant engineering solutions being done in the service of sort of silly policy decisions. Like growing alfalfa in California to ship to Saudi Arabia is a silly thing to do. And if you come to terms with that, there's more water in the river for other uses to discuss over. And I think both sides, if people want to talk about should we kick this species off the planet, I want to talk about should we get rid of alfalfa farming in the desert. Both extremes are out there, and they have to both be part of the conversation.
Thank you. Yes, back row.
Thank you. I'd like to ask your thoughts about the scale of habitat conservation programs or plans and whether we can string a series of them together, particularly in riparian and wetland corridors, so as to buy certainty for other development and effectively buy an insurance policy against future surprises.
I think, yes, the answer is, and I think there are some examples of, if you will, pilot projects of how that could occur, both within the United States and binationally. I think the multi-species conservation program in the lower Colorado River Basin it was exactly that in a way. It wouldn't solely be on riparian, but maybe because we were dealing with migratory birds and habitat in that way as well. But they pooled a lot of time, energy, and resources together to develop a plan to maintain, preserve, and protect and enhance the species for those habitats. That's an example. Another example, I think, is for a habitat conservation plan specific to the Endangered Species Act would be in the San Luis Valley on the Rio Grande, where you had varying interests get together and identify a plan that would help preserve the habitat, or designated habitat for critical habitat for designated species. And willingly and happily, I think it goes to some of their quality of life. The concern with that, though, is that they did it for the species that they thought they needed to protect. And then the next day, another species is listed that needs to be protected that doesn't fit within the plan. And so all of the energy and efforts don't have a long-term certainty that they're going for. And so that's where I think that we need to either tweak the concept of habitat conservation plans and the solutions that they provide under the ESA. And I think that would incentivize a willingness within the state and other citizens and other industries to be able to do landscape planning for species. But they have to know that the efforts they're doing are actually going to produce something that's going to benefit what they're trying to accomplish.
I would agree with what Karen said. I mean, there are some problems with guaranteeing certainty over time faced with evolving knowledge and changing fact patterns. There are two administrative policies in the HCP planning process. One's called Safe Harbor, and the other is called No Surprises. And they try to come to terms with these issues with varying degrees of success, but in a very superficial way. Safe Harbor is if you do something positive for the species, you'll be protected against having to further expend stuff if you benefit the species, it won't come back to haunt you. And then no surprises is if you agree to do X, Y, and Z, someone won't come back and say, now we got to have something else for this other species. So those policies were put in place to try to address these problems, but it'll always be an as-applied situation where you're talking.
And I think there's a provision, and I don't know that much about it, so I'm treading into dangerous area, but there is a provision in the Endangered Species Act under Section 6 that at least acknowledges efforts taken to develop and implement conservation programs even before a species is potentially listed, and that the Fish and Wildlife Service would take those types of actions into consideration when considering the status of a species.
Mr. Robbins.
Thank you, Professor Cheever, and I apologize if my voice not that good, but I'd like to ask the panelists to revisit the comment about ESA trumping compacts. I want to explain that from my perspective, I don't understand in our legal framework how that's possible. It seems to me that a compact is not an act of Congress. All Congress does is simply ratify and approve the actions of sovereign states who compromise and even relinquish portions of their sovereignty in order to reach a comity-driven solution to an interstate problem. And when Congress approves that, it isn't deliberating, it isn't making decisions, it isn't doing anything that a subsequent congressional action can overturn. Now, I'm not suggesting that Congress can't pass a bill that interferes with citizens of a compacted river or states' ability to use the water as they dream they would use it. But unless Congress were to try to say specifically, we're overriding this compact, I'd like to understand the legal theory, how a subsequent congressional action without ever mentioning a compact can somehow override it.
Either of you?
Go for it.
Oh, sure. So I look at it in a couple different ways with some limited data points. We know the Endangered Species Act will...
Can you turn your microphone a little bit toward you, or turn it on, it's a little quiet.
Is that better?
Yes.
Okay, sorry. So here's the data points we have. The Klamath situation, the cases that arose in the early 2000s, which went up to the Ninth Circuit and the Federal Court of Claims, will say that the Endangered Species Act will trump a water delivery contract from any of the federal agencies or a state water right that is derivative of the federal government putting the project in. Normally speaking, federal law will trump state law under the Supremacy Clause. So as a federal statute, the Endangered Species Act would be supreme to any state laws. As approved by Congress, I would look at the compact as just another federal law ratifying the agreement of the states. And I would put it on the same par as a federal statute, so that the two would have to be either read in harmony or somehow reconciled. Trump might not be the right word, particularly these days. I think neither can ignore the other is a better way to express it. If you wanted to say we're doing something consistent with the compact, I don't think that is an excuse for violating the Endangered Species Act. And nor is the reverse unless a court stepped in and ordered someone to do so. In other words, you couldn't say we're complying with the Endangered Species Act, we're going to violate our compact without being subject to those penalties as well.
I don't think I disagree with the way you've posited it, but your analogy to federal contracts, reclamation contracts, are simply creatures of Bureau of Reclamation law, which is congressional law. So ESA, certainly Congress can say a law that was passed in 1908 or whenever it was, we're changing the way this is going to be applied. But my point is only that the Endangered Species Act cannot work a change in the underlying apportionment, so that at the end of the day, we may have time periods where there are actual conflicts between people wanting to use water under a compact. But that doesn't disrupt or violate in any way the underlying apportionment, because it's not a congressional law.
To confuse the issue further, the Endangered Species Act is generally recognized as abrogating or potentially abrogating Indian treaty rights.
That's for Stanley to deal with.
Here he comes.
Oh, good. You're running, I can tell.
Okay, well, first I wanted to just say, I mean, I agree with what Dave is saying about the Act. I mean, it seems to me that the application of the Act is really, if water is curtailed because of endangered species concerns, it really has the same impact on compacts that drought does. Now, in terms of abrogating Indian rights, here's the trick. The tribal rights are not based on first in time, first in right. So that tribal reserved water rights vest as of the date that Indian reservations are created. They don't have to be put to beneficial use in order to be vested. Now, under the Endangered Species Act, however, and there's a caveat here because tribal water rights are much more susceptible to being curtailed under the ESA than state appropriative rights, because basically the tribes cannot really do anything on the reservation in terms of resource development without there being some degree of federal complicity. So you have Section 7 is always going to be involved in any tribal water development, whereas you don't have that in a non-Indian context. But when you go through the Section 7 process, there are interior decisions that say the Section 7 consultation must occur on a first come, first served basis. So what that does is it essentially flips the tribal rights on their head, because the tribes typically are the last to develop, even though they have the senior water rights. So if Section 7, where you're essentially doling out allowable levels of depletion from a river, you know, there's an environmental baseline, there's a certain amount of depletion that would be acceptable for a species. Once you're doling those out, if it's done on a first come, first served basis, the tribe is now the last to develop because they haven't had the resources. It's completely flipping the order, so you have a federal law that essentially has the effect of turning federal reserved rights into the equivalent of state appropriative rights. You, the tribe, have not developed your water. It doesn't matter that your water was vested as of the date the reservation was created, and so it does abrogate the very essence of the federal reserve right.
I would say on top of that, and I don't mean to be confusing things, but to the extent the Endangered Species Act requires, or the Fish and Wildlife Service requires there to be a bypass flow or a reduction in depletions to preserve the habitat for a fish species or whatever, that's fine. That happens. That does not mean that the state engineer or the state is going to be able to administer it just because the Fish and Wildlife Service wants it to. That's not a water right. We have to administer a water right. So it does prevent, and it still creates the complication for the water users because they can't get at the water that they're trying to get at without complying with the bypass flow or something. But that doesn't mean that Dick in our state is going to be like, oh, there's a bypass flow. Okay, we'll just make sure that happens, because the federal government, just like everybody else, has to get a water right for that to happen.
I think we're out of time. Thank you all very much.